Good afternoon, ladies and gentlemen. On behalf of Madhyam, it's indeed a great honor and privilege for me to welcome all of you to this webinar. My name is Ganesh Chandru, and I'll be the moderator for this afternoon's session. I'm sure many of you who are logging in from Europe or from Singapore or from the US, you may be in different time zones. Thank you so much for taking your time out on a Saturday to be part of this webinar on arbitrability of disputes, a cornerstone for arbitration. It's a very important topic, and we are indeed honored and privileged to have a stellar panel of speakers today. First, I would like to introduce them to you. I know many of you know them, but to those who may be seeing them for the first time, Mr. Gaurav Banerjee. Firstly, welcome, sir. Great to have you here today. Gaurav is a senior advocate practicing mainly before the Supreme Court of India. He's as well as an arbitrator and a leading counsel in a large number of domestic and international commercial arbitrations. He has also represented the Republic of India in investment treaty arbitrations. In addition to being a senior advocate in India, he is also an overseas associate of Essex Court Chambers, a very leading set in England. Mr. Gaurav Banerjee has also served as the Additional Solicitor General of India from July 2009 to May 2014. He has been part of various government and intergovernmental committees and has assisted the Law Commission of India in its reports relating to arbitration, particularly the 246th report on the amendments to the Indian Arbitration Conciliation Act, which we all know culminated in the 2015 amendments to the Arbitration Act. He's represented various parties in various high-stake matters in sensational cases. In fact, one of his recent cases is presently representing Amazon in the well-reported and talked litigation against the Future Group and Reliance, which also involved an emergency arbitrator proceeding in Singapore that was in the news all over a couple of weeks back, and Gaurav is leading Amazon in that proceeding. He's also the vice chairman of the UNCITRAL National Coordination Committee for India, and we really look forward to hearing from you, Gaurav, later today on arbitrability of disputes and your views on various facets on the topic. Next, we are indeed privileged to have Mr. Francis Xavier, Senior Counsel and Regional Head of Disputes Practice at Raja and Tan in Singapore. Francis was appointed Senior Counsel in 2009, and he practices international commercial arbitration, treaty arbitration, as well as commercial litigation. He is actively involved in cross-border commercial disputes, and he has the distinction of having appeared in the first ever matter that came up before the recently launched Singapore International Commercial Court, where Francis represented an Australian energy entity in a very substantial dispute against an Indonesian conglomerate. He appears as counsel regularly as well as arbitrator, both in ad hoc matters as well as arbitrations conducted under institutional rules of various arbitral institutions. We are indeed all the more honored because Francis today is the global president of the Chartered Institute of Arbitrators, UK, which is the gold standard for training of arbitrators in the world, and all credit to be given to him and his team for smoothly conducting training programs even in this pandemic in a virtual kind of fashion. I don't know how many of you read his message yesterday when he was giving the reins to the new president. Such a beautiful message, and all fellows and members should read it in your email if you have it in your inbox, as to how the world is and how Chartered Institute has played a great role in not only improving membership but also training arbitrators in this circumstance. So thank you, Francis, for that on behalf of the arbitral community, not just in India, but at world at large. And he was also the immediate past, forward to hearing you. And apart from legal advice, you could also go to Francis for advice for fitness. He's a real fitness person, and among his several hobbies of playing the drums for the Law Society's Singapore music band, he's also a mountain climber. So I think that's only the tip of the iceberg. So we really look forward to hearing your views on this topic. The next speaker is Schaefer, who is a partner with King & Spalding in Frankfurt, Germany. Jan heads King & Spalding's dispute resolution practice in Germany, and he represents foreign and German clients in international arbitration as well as domestic arbitration matters, not just commercial but also investor state arbitrations. He regularly appears before the German courts in various proceedings, especially taking of evidence for foreign proceedings, interim relief, and enforcement actions as well. But he, more than just being a counsel, at such a young age, Ian has acted as arbitrator in several cases. He's done more than 60 arbitrations as an arbitrator, both as chairman, party appointed, and also as sole and emergency arbitrator. He has been appointed by the president of the German Federal Bar as member of the Europe Committee and the Committee for Dispute Resolution for the term 2020 to 2023. So Jan, thank you so much for joining us on a Saturday morning, your time, and we look forward to hearing your views on this interesting topic. Without further ado, let me go straight into the topic: arbitrability, a cornerstone for arbitration. One thing which all practitioners, whoever are listening to this webinar, you will know that once an arbitration is completed and an award is made, the party which has not been successful looks at ways in which mostly some parties do pay up, but other parties who have not been successful look at ways in which you can have a recourse against an award. And one of the grounds under Article 34 of the model law, as well as it's replicated in our Arbitration Act here in Section 34, if the subject matter of the dispute is not capable of settlement by arbitration under the law of the seat where the arbitration is made, then you could challenge the award on that ground. And the same is also found in Article 5 2 of the New York Convention, which is actually also by way of implication our Section 48 of our Arbitration Act in India, and similarly in Singapore and other countries, where you can resist enforcement of a foreign award exactly on the same ground that the subject matter of the dispute is not capable of settlement under the law where you want to enforce the award. So therefore, it is very, very important. Arbitrability of a particular dispute is extremely important and goes to the root of the matter. Madhyam, when it came up with this topic and we kind of publicized this seminar, while we were kind of gearing up to the seminar this week, the Supreme Court of India, this just a couple of days back, this Monday, came up with a landmark decision in Vidya Drolia and Durga Trading Corporation on arbitrability. In fact, various facets of arbitrability were discussed in that case. But what we want to do today is to talk about arbitrability generally and talk about arbitrability in the context of intellectual property disputes, which I would be referring as IP disputes, as well as insolvency matters. So straight, let me go to Gaurav. Gaurabji, what do you think? I mean, I want to throw open this general question to you so that we have a mixed audience. There may be lawyers who know what arbitration is. There are also other lawyers who may want to get into this field. So what is arbitrability and what are the different facets of arbitrability?
So thank you, Ganesh, for that wonderful introduction. It almost read like an obituary, but thank you for that introduction, that glorious introduction. But be that as it may, the word arbitrability has so many different meanings, and at least three different meanings have been spelled out in judgments of our Supreme Court. One facet of arbitrability, which you mentioned just now, and you mentioned Article 5 of the New York Convention, 5(2)(a), in fact, and you mentioned the model law, is that, there may be some disputes which are just simply not capable of settlement by arbitration. So that is one core aspect or facet of arbitrability. And I think that's really what we are going to discuss in relation to IP, or whether it's in relation to insolvency. There are some categories which the legislature feels or the law feels you should keep out of private dispute resolution. So that's category one. There are other categories, even if you clear this hoop. So that category, if I can define it, is disputes which are quote unquote not capable of settlement by arbitration. And that's the language which we have used in section 34, which is similar to article 34 of the model law. We've used in section 48, which is similar to article 5. And we've also used in section 2(3) of our act, which says, there are disputes which are not capable of settlement by resolution by arbitration. So that is what we will be discussing today. There are other meanings of the word arbitrability. Supposing you have an agreement, and that agreement keeps certain issues out, say accepted matters. That could also be an aspect of arbitrability in a particular situation. Or you have an arbitration agreement, but when you refer a dispute to arbitration, you don't refer a particular dispute. That could also be arbitrability. So these three categories, in fact, were formulated by Justice Ravindran in the famous Booz Allen case, which I'm sure many of you have heard of, and Booz Allen, which is a 2011 case, and which has now been, of course, repeated and affirmed and set out in that very recent judgment which you just mentioned, which came on Monday, Vidya Drolia, which is a sort of an encyclopedia of 150 paragraphs of Justice Sanjeev Khanna's judgment, plus some more, so 230 pages. But really, it just clarifies the Booz Allen principle. So that's essentially what arbitrability means.
Thank you. Sir, Gaurav, you were referring to Booz Allen case just now, when the Supreme Court, I think, set out a rights test for determining arbitrability. Can you elaborate on that and also give some examples of non-arbitrable disputes?
So I will certainly refer to Booz Allen, but I will also refer to this new case of Vidya Drolia just to answer that question.
Oh, yes.
Sure. The question, so what happened in Booz Allen? So what happened in Booz Allen was that Justice Ravindran sought to draw a distinction between actions in rem and actions in persona. And that was basically the theme of his judgment. But what he did also in that judgment, as you mentioned, is that he drew up a laundry list of items which he said were not arbitrable. So the list that he said was not arbitrable, well-recognized examples according to him were disputes relating to rights and liabilities which arise of criminal offenses, obviously criminal offenses. 2, matrimonial disputes, divorce, judicial separation, restitution of conjugal rights. 3, guardianship. 4, insolvency and winding up. Of course, we'll be talking about this specifically. 5, testamentary succession. 6, eviction or tenancy matters governed by special statute. So this was a list that he gave. Now, this list has been improved upon, added. There are cases of consumer disputes in MR. There are trust cases in Jayesh Shah. So this list kept getting, shall we say, increased or expanded. So there were certain examples which were given. But what has changed, and I think it's very important to understand that what has changed now is for arbitration lawyers that rather than looking at a list and trying to fit your case in or come out of a list, the new judgment of Vidya Drolia, and if you just give me a couple of minutes, I just want to explain what it was all about. So Vidya Drolia was a really simple case. It was a simple tenancy dispute. And one would have thought that it is obvious that tenancy disputes, by and large, are arbitrable. But one court in Himangi held that it was not. And then you had a reference, you had another court saying no, referred to a larger bench, and Vidya Drolia came before 3 judges. And essentially Vidya Drolia holds, and which was quite an easy hold, that if it's not under a special statute, like a rent control statute, then of course it's arbitrable. But what is interesting about Vidya Drolia, and I was trawling through those 230 pages, the interesting thing about Vidya Drolia is that Justice Khanna has formulated a 4-fold test to decide whether or not an issue is arbitrable, whether a particular issue, and maybe we can apply that test to our IP discussion or our insolvency discussion, but this is his test. And it's quite an interesting test that he has involved. Some parts of it I may or may not agree with, but it's there. First is is the cause of action and subject matter action in rem that does not pertain to subordinate rights in personam that arise from rights in rem. So that action in rem, action in personam. 2, whether the cause of action has a third party effect. 3, whether it relates to the sovereign and public interest functions of the state. 4, whether it is arbitrable as per statute. So he says these are 4 tests. He then says these are not watertight compartments. You have to look at the matter holistically. So this is what is interesting about this judgment, that instead of a list, which of course he follows the Booz-Allen list, he seems to suggest in paragraph 60 and 61 some sort of test for arbitrability or non-arbitrability. So that's really what I take away from this judgment at the real sort of, that's the real important takeaway from it. There are some other aspects of prima facie, etc. We can go into that. So to answer your question, there is no longer simply a rights test for arbitrability. There is now a 4-fold test.
Thank you. Thank you. That's interesting development in India, just out of the box just a couple of days back. Now we have seen what arbitrability as well as non-arbitrability is generally. Now we'll move on to intellectual property disputes and arbitrability. Here, moving to Francis. Francis, can you share your thoughts on arbitrability of IP disputes? Especially, we understand that in Singapore, there's an exclusive legislation that deals with resolution of IP disputes, and pursuant to that, there are consequent amendments to the International Arbitration Act as well as the Domestic Arbitration Act in Singapore. Could you throw some light on that, Francis?
Right, Ganesh. I mean, we are back to the same analysis that Gaurav very helpfully elucidated. The question is, arbitration is private consensual dispute resolution between 2 parties, and that's it. Only parties to the arbitration agreement are affected, right? Intellectual property rights, let's just call it IPR. IPR affects the whole world. If I have a patent in something, nobody else in the whole world can assert a right in that IPR, right? Subject to registration and all that. Of course, different jurisdictions have different registration mechanisms. But I can assert that right against anybody, right? And so the question is, how does a very narrow dispute resolution mechanism between 2 parties to an agreement operate in this space? And internationally, the world is not in unison, right? So you have extremes. On the one hand, you have the US, where very extensive IPR rights, either the in personam rights, the subordinate rights that Gaurav talked about, or the primary in rem rights of the IPR itself, the patent, copyright, trademark, very extensive rights to arbitrate in the US. Then you have the other spectrum, South Africa. Article 18 of the Patents Act in South Africa makes it very clear, no arbitration at all in the IPR space is permitted. Now, most countries, Singapore included, take a middle ground, which is the primary right, bundle of rights, the rights relating to the IPR, which operates in rem, as Gaurav has explained it, against anybody, right? Not just contracting parties to an arbitration agreement. That is not arbitrable, right? But subordinate rights, which arise, for instance, I have the IPR and I license it to you. And we have a problem with the licensing arrangement. That is just between me and you, doesn't affect anybody else. And so that can be arbitrated. And this was made clear by August 2019 legislation, the IP Dispute Resolution Act, with, as you rightly say, that is the tail end, the repercussions in enforcement of arbitral awards. And so the law was also made clear to say you can arbitrate and you cannot set aside an award just because it's a subordinate IP rights arbitration matter that has resulted in an award. And so in Singapore, it's quite clear that IP disputes operating in personam can be arbitrated.
Thank you so much. We always, when we talk about seats of arbitration in Asia, we talk about Singapore, and the next thing is Hong Kong. What is the position in Hong Kong? It'll be useful for us to also know the position in Hong Kong.
Similarly, Ganesh, because for a while, both in Singapore and Hong Kong, there was uncertainty as to what the position was. So Hong Kong too took steps, in fact, earlier than Singapore. It passed legislation, the Arbitration Amendment Ordinance in 2017, which came into effect in January, 1st January 2018, making the same point clear, right? Effectively, it says the same thing now, but I just want to just add one thing, right? So what is happening is you have arbitral tribunals are now going to be ruling on this in personam rights as between two parties, right? Now, arbitration operates very differently from a court, right? A court will have stare decisis. Hong Kong, Singapore, most common law courts in India,
Yeah.
we are bound by stare decisis. An arbitral tribunal has no precedent, no stare decisis affecting them. So there is a great scope for an arbitral tribunal to come to a completely different result from a national court. So what you're going to have is subordinate rights in personam being fought in an arbitration, and in rem rights being fought either in Hong Kong, India, or Singapore. And because the structure of arbitration and the structure and the philosophy of court litigation is very different, the key being the stare decisis principle being absent in arbitration, you're likely to get very different results. And when that happens, I think we haven't seen a case yet, but I will foreshadow that we're going to start seeing cases where there's going to be a conflicting decisions, and the ripple effect, it's going to be quite interesting to watch. Back to you, Ganesh.
Yeah, thank you, Francis. Yes, that's one thing in arbitration, that we don't have precedents, and we can't, the doctrine of stare decisis doesn't really apply. Moving on, we've seen India, we've seen South Asia, we've seen parts of Hong Kong. Moving to Europe, Ian, coming to you, can you enlighten us on arbitrability of disputes, especially IP disputes in the European context? Are there provisions in national statutes or civil codes or in EU laws, for instance, in this regard? Could you just give us a ballpark picture of the European position on this?
Yeah, I'm happy to do so. Thank you, Ganesh, for the invitation. It's a great pleasure to be participating in this seminar today. Maybe let me start off with speaking to arbitrability as a general concept as it's understood in continental Europe. So that's a civil law perspective on the concept. In the beginning, it was said it can have different facets. And if I speak about arbitrability as a civil lawyer, I'm only referring to the question of whether a dispute can be submitted to arbitration. So this is a very limited view on the concept. And that's the question which is answered by the law, by the lawmakers in the statutes, or by the judges when they come up with interpreting the statute in a civil law context or in the common law context by establishing common law. The question of whether the scope of the arbitration agreement covers a specific dispute, that's a question that is answered by interpreting the arbitration agreement. So that's interpreting not the law, but interpreting the party autonomous kind of framework that the party set. So I come from a very, very limited perspective on arbitrability. Then if you look at it, I think you've already mentioned the New York Convention. Also in Article 2, there's a reference whether the dispute can be submitted to arbitration. But then the big question arises, okay, what is the test for this? And if you look at the New York Convention, it doesn't find a test. If you look at the model law, it doesn't find a test. So basically, this is an area where you have a diversity of different approaches. It's the legislator who determines, okay, I want to put up a limit here. Arbitrability is the confines of the world of arbitration, so to say. And if you look at it in a European context, in certain arbitration laws, you find reference to arbitrability, and in others, there's no reference at all. For instance, if you look at French law, and France is a very, very prominent seat of arbitration and place of arbitration in Europe with the ICC headquartered there, you don't find any reference to arbitrability. What the French do, they say, for international arbitration, we have a concept of international public order. And all the questions of arbitrability, they will be covered by that concept. If you look at other states, they have spelled out own rules on arbitrability. And I think Germany has done a very elaborate provision on arbitrability. So maybe this is the reason why you put a German on this panel here. It says all claims or all disputes arising with a pecuniary interest, they are arbitrable. So if you have a claim for cash, it can go to arbitration. And we say if you don't have a claim for cash, then it's arbitrable if the parties can make a settlement over the topic, or if they can waive the rights. And that has been a very traditional test applied in several jurisdictions. But then the question arises, okay, which law determines whether a party is entitled to settlement over a certain dispute? So adopting this kind of principle of if it's a kind of a monetary claim, if it's a kind of an economic interest underlying the claim, then it's arbitrable. This is a much easier test. Of course, you still need to construe it. And then in the German provision, you find limitations, like if it's a residential rent contract, this cannot go to arbitration. And the same is, there's a kind of a catch-all clause. If somewhere else in the German law, there's a limitation to arbitration, then this will be accepted. So if you read the German arbitration law, you get a test, but you don't know the full picture. You need to get to know more things. And if you look at other European laws, they apply this test of, yes, you can, if you can settle, that's a kind of dispute that can go to arbitration. But as I said, then you need to determine the law applicable to the question of whether you can settle or not. Now, against this general picture, applying it to IP disputes, again, you have a very broad range. You have the Swiss on the one hand side, which are very, very liberal and very open to getting IP disputes into arbitration. Even arbitrators can determine the validity of a patent, which normally would not be a subject matter for an arbitrator. And what happens if an arbitrator finds that in an inter partes dispute, as was already mentioned, this is just the privy of the arbitration clause, it doesn't apply to everyone. But if the arbitrator finds that the patent is invalid, then if this arbitration award is recognized in Switzerland, you can go with that arbitration award to the patent office in Switzerland, and they will recognize this. So they will take out the patent from the register. This is a very, very, very far-reaching power that is granted to an arbitrator, which you don't find in that extreme in other places in Europe. In some places, there's even the position to say, well, this is a turf wholly outside of the scope of the arbitrators. And then there's the kind of the middle ground, the gray area, and that's a kind of a moving part, because there's a sentiment that arbitration is an equal mechanism to litigation. So there is a kind of a question: why shouldn't a dispute go to arbitration? It's a judicial process with right to be heard, with equal treatment. And in that context, you have this middle ground where a lot of people say everything which stems from an IP right, being like license disputes, and even the validity of a patent in the inter partes relationship, that can be determined by an arbitrator. But an arbitrator cannot make any determination erga omnes, so between everybody involved. And since a patent is a kind of an absolute right, of course, the question of whether this exists is fundamental, not just to the people involved in the arbitration, but the outside world as well. So that's a kind of a gray area. It's a moving area, but I think the sentiment in Europe is to get more IP disputes into the realm of arbitration. And when it comes to European regulation, for instance, the regulation on the enforcement of judgments, there's this carve out. They say, well, certain questions, they go for jurisdiction to specific courts. But the regulation itself doesn't speak to arbitration. It's expressly excluded. And I don't think that this argument saying, I determine the question of whether a dispute is arbitrable, I'll need to look at the court rules, is very convincing. Because the court rules deal with the court track, but arbitration is a different track. I think similar to what just has been referred to in India, you need to have a substantive test. What is the criteria for a dispute to be arbitrable? It's not just looking at court rules and saying there's an exclusive jurisdiction of a certain court for a patent matter, and because we have this exclusive jurisdiction, we cannot arbitrate the dispute. I think that's too formalistic. I think you need to look into substance, and that's an evolving field. Thank you, Ganesh.
Thanks, Ian, for laying the ground. And you've covered Europe generally on arbitrability as well as on arbitrability vis-a-vis IP as well. Coming back to home ground, India, Gaurav, is there a blanket ban on bar to arbitrate IP disputes in India? And if so, is it not impractical and against commercial sensibilities to consider the entire realm of IP disputes inarbitrable? So what are your views on this?
So before I give you my views on that, could I just react to what Jan says? I think
Sure.
one of the tests that Jan formulated perhaps should have gone before the Supreme Court. The test that if you can settle with money, then it's
Yep.
arbitrable. Maybe that should have been added on to Justice Sanjeev Khanna's list of tests. Maybe that is a very, very good test, and if that is how the
Yeah.
civil law looks at some issues of arbitrability, maybe we should, in our next round before the Supreme Court, try to put it in. Anyway, that's just by way of comment.
Sure.
But so far as IP disputes in India are concerned, we really do not have a definitive ruling from the Supreme Court. You have a comment of Justice Chandrachud in Ayasami, which is that fraud case which you would have heard of, whether fraud is arbitrable or not. That's another interesting rabbit hole we can run down, whether fraud is arbitrable or not, the extent of arbitrability of fraud. We park that question, where while discussing that, he, in a throwaway sentence, suggests that issues regarding patent, trademark, and copyright are not arbitrable. But that's really not how our high courts have looked at it. And interestingly, in the new judgment of Vidya Drolia, there is one, again, throwaway sentence on copyright, where Justice Khanna says, therefore, a claim for infringement of copyright against a particular person is arbitrable. Though some manner, the arbitrator would examine the right of copyright, right in rem. So, we have no real clarity at the highest court level. However, now we come to the however. This issue has been raised in the various high courts.
Yes.
There are 3 or 4 judgments in the Delhi High Court. For some reason, there are a plethora of judgments in Bombay, 7 or 8, all pointing in distinct and different directions. There are a couple of judgments in Madras High Court, a couple of judgments from Hyderabad. But really, I mean, if you are looking at a trend, then if you look at the trend, I would say that there are 3 judgments, couple from Bombay, 1 from Madras, which point to arbitrability. The general consensus now seems to be that if it is a subordinate right in personam, it is arbitrable. Another way judges get around this issue of in rem in personam is casting it as a contractual right. So you are asking for relief, not enforcing your patent, not enforcing your copyright or trademark, but enforcing your license, which is in some sense a contractual right. So you cast your relief in contractual terms to get out of the debate. Or you go the other way by saying it's a right in personam, not a right in rem. But the trend is, I mean, there are older cases. I mean, there are cases the other way. There are cases where the Bombay High Court has said, sorry, can't be adjudicated at all. It's a right in rem. There's a case called Indian Performing Arts Society, which says that. The contrasting case, if you had to read only one judgment, it's a judgment by Justice Gautam Patel in Eros International. Yep. You would have come across Justice Gautam Patel. He writes in a very, florid and very entertaining style. I mean, some of his, and even in court, he's very entertaining. But a judgment by Justice Patel. There's a judgment by Justice Indira Banerjee when she was in Madras. There's a judgment by the Delhi High Court. So there's no clarity. But I think now with the Vidya Drolia story, because there's a second limb to Vidya Drolia, which I had not mentioned, which is question 1, what is arbitrable? Are IP disputes arbitrable? To what extent are they arbitrable? Question 2, who decides whether they are arbitrable? And now our Supreme Court is suggesting, not suggesting is a weak word, is saying very strongly that you have to leave it in the first instance to the arbitral tribunal, unless it's a gross case. It's ex facie, not arbitrable, the general proposition. So you leave it to the arbitral tribunal, and you then have a second look at the 34 stage, or the setting aside award stage, at the stage of challenge to the award or enforcement. And I just go back to what Jan pointed out. Jan mentioned Article 2 of the New York Convention, which is at the stage where you are trying to get a matter referred to a panel, an arbitration tribunal, which is our Section 8 in Part 1, where you basically ask for a stay of a proceeding and push it to arbitration. And then the words used are null and void, incapable, inoperative, incapable of being performed, the classic New York Convention model law language. There, Justice Sanjeev Khanna says, even in such a situation, when you look at arbitrability, it's really a prima facie view, and unless it's pretty blatant, you permit, when in doubt, refer, is what both sets of judgments say. So I think the good news is that virtually all IP disputes ought to now be arbitrable, other than extreme cases where you're trying to enforce a patent against unrelated parties when you can't go to arbitration. So I think the pendulum in our case is swinging in the right direction. So
Thank you.
That's good.
Yeah, so virtually all disputes, and not only that, virtually it's even virtual hearing now. So, so everything is virtual now. So, but that's great to hear. I think this decision definitely has provided some clarity. And thank you, Gaurav, for also taking in making some useful comments on what Ian said in terms of Article 2, as well as I liked your point about this settlement with money, which is, I think, an excellent test, because even when we look at, I'm sure Francis will also agree, when we enforce foreign judgments in common law countries because of our provisions in our Civil Procedure Code, as well as under the Reciprocal Enforcement of Commonwealth Judgments Act in Singapore. I think the thing is, if it's a money judgment, then there's no question, it's just enforced. So I think that maybe just for purpose of analogy, I referred to that, but that could also, when it's a payment of money, then it's a commercial case when it's between parties.
But the question,
so
Ganesh, is if we have that test, sorry to interrupt, if we have that test,
yes,
hypothetically, in some countries, you settle marriage disputes with money. I mean, maintenance issues are regarding money.
Yeah.
Would that be arbitral? Maybe in some countries it is. It is. But whether we would in our country say matrimonial disputes, divorce is of course a sort of a break, but maybe settlement, maybe maintenance. Why should maintenance not be arbitral? Hypothetically. So interesting question. Anyway, sorry for that.
No, I think arbitration is also a field which is evolving, and as long as we can bring in more within the ambit of arbitration in a private setting, especially in a country like India, where this docket explosion in courts, I think it's definitely will be useful for dispute resolution process. Now, parking IPR rights in a corner and moving to insolvency and arbitrability, Francis. Generally, I mean, what are the claims involving claims involving an insolvent company per se arbitrable? In this context, of course, all of us know this famous judgment of the Singapore Court of Appeal in Larsen Oil and Petropad, which is a leading judgment in the common law world of Honorable Justice V.K. Raja when he was on the Court of Appeal. So could you elaborate on that, and as well as maybe talk also about oppression, and under the Companies Act, whether these can be arbitrable. So two facets. If you could just throw light on that, that'll be very helpful.
Before I answer you, Ganesh, I'm just going to take a very quick detour on this divorce thing that Gaurav spoke about. It is a fact that many jurisdictions today recognize that you can employ arbitration for the plethora of subordinate disputes, using the terminology of Gaurav, that comes up. Obviously, an arbitral panel will not be able to issue a decree of divorce, but issues of maintenance, issues of division of property, that is now routinely being arbitrated in the US, in Canada, and other countries in the world. So as Gaurav says, and you put a keen finger on the pulse of that, it's a living organism, right? And the ambit of arbitrability is getting wider and wider because of the acceptance of arbitration as a very effective dispute resolution mechanism. Now, but coming back to insolvency, so on insolvency, I think it's very helpful. What are the limits of arbitrability? And the Vidya case that you and Gaurav spoke about is very interesting. There were 4 tests that was, I haven't read the case, but listening to Gaurav, I've gotten a legal education. The first test is it in rem or personam? The second test, are third-party rights affected? And the third test is it something created by the sovereign involving public interest? It seems to me that all those three tests are effectively different ways of looking at the same test. I mean, Jan put it as, obligations erga omnes, rights erga omnes against the rest of the world, affecting third parties, created by the state, and really they operate in rem. It seems to me that those 3 tests can be collapsed into one test, right? So if you apply that one test in the area of insolvency, and that will explain very succinctly the 2011 decision of the Singapore Court of Appeal in Larsenal, which you've flagged, which is that if there are disputes that arise the minute a company enters into insolvency, then those disputes are not arbitrable, because it's obvious, right? Because all disputes, once insolvency starts, will affect the body of creditors, right? So the obligations, in rem obligations are involved. So no arbitration can determine those rights. So pre-insolvency disputes emanating pre-insolvency that do not affect the body of creditors occurring between parties, and Gaurav has an interesting way of framing it, arises by way of contract, purely by way of contract between 2 parties, as does the arbitration clause philosophically. So that can be arbitrable, even if it's in the context of an insolvent company, right? Now, but I want to move on to the second hydra of your question, which is the minority oppression, and that comes back to the last test in this Vidya Drolia case that Gaurav has been explaining, which is, I got it down. Does the statute make an action non-arbitrable? Now, this is a very important thing, and I think we're going to see a lot of development in this area in the years to come. So, coming back to the minority oppression case, right? Now, what is minority oppression in Singapore, and in many other countries? A minority oppression claim arises out of statute, right? So you have a minority shareholder who's getting bullied by the majority. So in Singapore, Section 216A of the Companies Act provides for the minority shareholder to go to court to say, I've been oppressed, either order a buyout, force him to buy me out, or allow me to buy him out, or alternatively wind the company up. So the question arises, this cause of action is, a statutory cause of action. And so the question has come up in Singapore and decided in the Court of Appeal case of L Capital Jones in 2017. The court says, look, the underlying disputes as to whether you've been oppressed, there is no reason why you can't go to arbitration. Now, the arbitrator can order a buyout. He can't order a winding up, but so what, right? There is nothing inherently contrary to the statute for an arbitrator to determine issues of oppression and consider issues of a buyout. Now, if based on the arbitrator's findings, you can always go back to the court, and this is what the court says. You can always come to the court and say, by the way, because the arbitrator has found A, B, and C, which are actually the grounds upon which a court will rely on to wind the company up, the court says, look, come to us post-arbitration and we'll order a winding up if we think it's appropriate. So that is very interesting. And the same sort of thinking has been traversed in London. In the UK case, the Court of Appeal case of Fulham and Tottenham Hotspurs, I'm sure the football fans would be fully on top of that case in 2012. And in Hong Kong, a similar line of thinking by Harris Jane, the Quicksilver case in 2014. Right. So there you have it, that last bit. So, the Drolia case on Monday, interestingly, that last bit, has come up for statutory causes of action. Thank you.
Oh, that's excellent, Francis. It's very nice you had a line of cases and how you connected that to the 4th test in Drolia. That's a hallmark of a senior counsel. I'm sure Gaurav will agree with me on that. It's very, very glad to hear about these cases actually, and I'm sure there are cases in India as well on several cases, following the old rule of force versus Horbottle on oppression of minority shareholders in India. Ian, now let's move to Europe again on insolvency and arbitrability. What is the position in Europe? I'm sure Europe is not a small place. I'm just throwing this thing about Europe in entirety, but you can choose the jurisdictions that you are comfortable with and are important for this purpose. What is the position there on insolvency and arbitrability?
Maybe to make it simple, because there are so many different regimes. On the one hand, there's the regime to say, well, once there's an insolvency, the arbitration agreement has no longer any effect. So that means if you are in an arbitration, the arbitration stops and you are in a court regime. On the other hand, there's the position to say, well, in an insolvency scenario, it doesn't affect the arbitration agreement. What the insolvency scenario does is, then an insolvency administrator comes in to ensure that all the creditors are treated equally. And that means that nobody can get a claim, a payout under a court proceeding, under an arbitration agreement individually, but you have to so to say, register your claims with the bankruptcy administrator, and they put the claims in a list. Of course, they are undisputed claims. They will come into the list. And once you know how much money is in the box to be paid out, you get your quota on that. But what most of the time happens is that there are disputed claims. So the company didn't pay because they said we have defenses against the claim raised, or even the insolvency administrator has claims against contractual parties that the insolvency administrator wants to pursue. And once the arbitration agreement stays in place, this means that an arbitration can continue. The insolvency administrator would step in the arbitration, take over, so to say, the role of the party representative from the management. So it would be the insolvency administrator pursuing the claims on behalf of the estate. And then if the claimant party, they cannot ask for a cash out, but they have to ask, and they have to change their prayer for relief. They have to say, I want the arbitrator to determine that amount X of my claim has to be put into the kind of register of claims as an undisputed claim. So if there's a payout under the estate, because there's still some money available for distribution, I get the quota that is available on my claim. But this is then an undisputed claim once it went through arbitration. So normally the arbitrators, they stop the arbitration for a moment, give the insolvency administrator an opportunity to look into the case, to make up the mind. Does he or she accept the claim, or does he want to continue disputing it? And then they need to pick up the arbitration. So you find quite a few insolvency administrators being parties to an arbitration. And now in the COVID-19 situation, and there's a moratorium on bankruptcies at the moment, at least in Germany and in other European countries, everybody expects that there will be quite a few insolvencies going forward in next spring when this moratorium ends. And then we'll see how this plays out in arbitration. But the same applies if you have a claim of the estate that the insolvency administrator pursues it. And one very famous example of a German company against an Asian state was the insolvency administrator of Walter Bau. He pursued a claim against Thailand on the construction of a tall highway. And that means an insolvency administrator, you see them in arbitration, either on the defendant side, when they still go against claims raised by contractual partners of the insolvent company, or they bring themselves claims so they can increase the kind of the cake that's available for distribution in the bankruptcy. Thank you.
Thank you, Jan. I think COVID itself, I think there are certain provisions as well as in India which came into effect because of the COVID situation. But let me not digress on that. I want to ask Gaurav about moratorium, which Jan just raised. What is the effect of moratorium on under the Indian Insolvency and Bankruptcy Code? India had an insolvency bankruptcy code that was enacted in 2016 on arbitration proceedings. What is this effect of moratorium and IBC on arbitration?
So this is interesting because as you know, Booz Allen notes that insolvency and winding up is a non-arbitrable area. And as Francis has explained, the reason is obvious. When you are in an insolvency situation, you are affecting a very large number of people. So obviously, you cannot have an arbitration which, in some sense, supersedes the insolvency process. So, as Jan was explaining, they have a different way of resolving this tension between insolvency and arbitration. In our jurisdiction, we have not quite worked it out. The idea is, once you trigger the insolvency process, whether by an operational creditor or by a financial creditor, you then get to a situation that there is a moratorium, so that you cannot really proceed against a corporate debtor. I mean, there is a bar. So essentially, if the arbitration is started post the moratorium, of course, it is void according to Alchemist. So that's fine. What happens to an arbitration which has been started prior to the moratorium kicking in? Well, of course, you cannot proceed any further. Then it gives rise to the question: what about the fact that the corporate debtor has counterclaims? Well, one view is there is no bar to the counterclaims. But how do you then proceed? The corporate debtor proceeds on his counterclaims, whereas the creditor cannot proceed on his claims. There are some authorities which say, since they are inextricably connected, both will proceed. So there is some element of gray area there. But the idea is that the moratorium gives time for the resolution plan. We have in India a concept of resolution and then liquidation. The two-step. First, try to resolve by a resolution plan, failing which, of course, this is not an IBC discussion. And second step is the liquidation. So what happens if you have a resolution plan is that obviously the resolution professional takes into account various claims, some undisputed, some disputed, goes to the committee of creditors, and you have a plan. Now, there's a very interesting angle to this. What happens post the resolution plan? Does the claim of in the arbitration simply die? Is it covered? Is it all over? Does the arbitration miraculously revive and continue while the liquidation is going on? Supposing it's liquidation, the arbitration may continue. But supposing there's a resolution plan, does the arbitration proceeding come to a complete halt? I would have said yes, but there is this inherent tension, and I know of cases where the arbitral tribunal has said no. How can you prevent a person from his remedy without understanding the nature of an insolvency proceeding, which is a settlement in rem? Arbitrators have taken a view that no, we'll continue and we will decide, because it's outside the resolution plan. So the new party is going to have to face this arbitration. So it's the moratorium has an impact. The contours of how much impact it has is still a little gray. But it's at least clear that while the moratorium is in place under 14, you can't proceed. That much at least is clear.
Yeah. Thank you so much. And also, it there are judgments on 34 as well. Section 34 proceedings, whether they could go or not. This is all evolving as we go, because as you rightly said, there needs to be specific law laid down on this, like it was laid down in Singapore as well as the other countries that Francis was alluding
in fact,
to.
picking up from what Francis said, it will go in the fourth principle, that it's statute, which is all those four principles are overlapping, of course. That if there's a specific statute which acts in rem, surely arbitrators should realize that really it's not their realm to second guess IBC proceedings. But we'll have to see. Sorry.
Sure. Gaurav, one more question which I had for you, because in India we have this existence of a dispute under Section 8 of the IBC code. What do we understand by the expression existence of a dispute under the IBC and its effect on arbitration proceedings? I know you did a case before the Supreme Court was one of the landmarks decision on this, the Kishan and Vijay Nirman case. Could you elaborate on this?
So essentially, you know, before you trigger the IBC process, you are you trigger it either as a professional, either as a financial creditor, which is a little different, or you trigger it as an operational creditor, basically supplier of goods, etc. So one of the questions that really comes up, and it comes up the worldwide, is: are you misusing the winding up process or the insolvency process just to get your claim adjudicated? And therefore, if there is an existence of a dispute, then you would not really be permitted to go through the IBC hoop. You would have to then pursue your normal remedy, whether it is court, whether it is arbitration, etc. So this expression, existence of a dispute, has been explained by Justice Nariman in the famous Mobilox case, where he essentially says that if you have essentially a plausible, and I'll try and read to you I think the line is, if there is a plausible contention which requires further investigation. It's not a patently feeble legal argument or an assertion of fact unsupported by evidence. If there's a plausible contention, then you are out. You do not go to IBC, or you do not go to insolvency. Then you follow the normal route. So in the K. Kishan case, which you were mentioning, where I was appearing, the other side had an arbitral award in its favor and tried to get it enforced through the insolvency route. The Supreme Court said no, the challenge to the award is pending. There are some issues which are there in the challenge on counterclaim, etc. So there is a plausible case. So now please go the normal way, fight it out in 34. You cannot go down the IBC route. So there is a little tension between arbitration and the insolvency fora. Each thinks they are superior, but if I had to pick, though I'm an arbitration, I do a lot of arbitration, I do a lot of IBC. Ultimately, the IBC must necessarily reign supreme, because insolvency solves the problem of a
Yes.
rather wider range of people.
Right. Thank you very much. That kind of brings us to the broad discussion on arbitrability generally, on IP disputes and arbitrability, as well as insolvency disputes and arbitrability. The floor is open for questions. We have a couple of questions, and if I can just look at some of them. The first question is: should arbitral institution set out an advance ruling of sorts to disputes envisaged by parties in a contract, borrowing from Gaurav's view on contractual disputes? Do you understand the question?
I'm trying. I mean, I suppose the idea is that an institution says, well, these disputes are arbitrable and these disputes are not arbitrable. That might be very difficult to do in practice.
Yes. Yes.
I do wonder how it works, but you know, I don't even think it can be solved by statutory intervention.
Yes.
This is judge-made law.
Sure.
And I think even in a civil law system such as in France or Germany, I don't think, subject to what Jan says, that it's very difficult to define with any degree of precision what is arbitrable and what is not arbitrable.
Yeah, I agree. Ian, any views whether arbitral institution can lay down some kind of guidance note on what is arbitrable or not?
I don't think that that's practical. You know, at least from a civil law standpoint, if you look at the concept, because it's a question of law, it's either the statute, the lawmakers put it down, or then how the judges apply it. Even so, we don't have this kind of notion of precedent. Of course, judges are critical and central in civil law system to help the parties understand what is the scope of these rules, like it's a monetary claim and so forth. But arbitral institutions are just nothing else than what the parties do. It's a kind of a creature of contract, and they can determine the scope of the arbitration agreement within what have the parties turned over to arbitrators to decide. But that's a question of contract interpretation, not of statutory or law interpretation.
Yeah.
Ganesh, could I just add this?
Francis?
I think it goes back.
Sure.
It goes back to what you said, right? Arbitrability arises really in two scenarios. The first scenario is it within the purview of the tribunal? So I think the answer to the question is certainly not the arbitration institution. If you're talking about LCIA or SIAC, you were with the SIAC, right?
Yeah.
But really, as Gaurav and Jan points out, it really is in the preserve of the arbitral panel, the tribunal, right? So an arbitrability issue will crop up, at an early stage of the arbitration. Maybe there are ongoing judicial management proceedings and so on. So as Gaurav has flagged out, so, the arbitral tribunal can rule on the issue of, does it think that this is not arbitrable or justiciable before it, the issue. But it doesn't matter, right? Because on this issue of arbitrability, my sense is it is the courts, the relevant courts, who will finally have the last say. Because even when the arbitral panel says it's arbitrable, in most jurisdictions, negative, positive rulings on jurisdiction appealable to the courts of the seat, right? So the court seats, municipal courts of the seat, will play a supervisory role over that. The arbitral tribunal, unfortunately, will not have the last say. And even if it gets past that, as you and Jan and Gaurav have highlighted before, at the stage of enforcement of the award, either the seat courts or some foreign court which has to enforce the award will preside over this very issue. So ultimately, as Gaurav himself had said, the arbitral tribunal has a limited amount of say, competence, but ultimately, I think the courts will really have the last say. Over to you, Ganesh.
Yeah. Thank you, Francis. Thanks, Jan and Gaurav as well. I just recalled when I saw this question about arbitral institutions, whether they can. The only thing I recall is in 1996, the ICC came up with this report on arbitrability of IP disputes. But that was nothing like it was just a kind of a collation of laws, statutes of various countries and rules of institutions, if at all they were talking about arbitrability generally. And in fact, that was the report where I think I first saw about the Swiss law, which was perhaps then the only country which had an express provision in its legislation, in its civil code about patent disputes being arbitrated. That apart, I don't think there's been any, there could be institutions which work on it more as a research or a source for people to look at. But for institutions to have a mechanism is going beyond what the jurisdiction of the arbitral tribunal would be, because even in this case of Vidya Drolia, the court said that you have to first leave it to the arbitral tribunal to look at whether a matter is arbitrable. Then, of course, you can always challenge an award on this ground, and if you think the matter was non-arbitrable. We have a little time left, and I have a couple of points.
I have a question for
yes,
this thing. For my fellow panelists and also to you.
This is sounding dangerous, Ganesh.
Yes, it's a dangerous question. So let me play devil's advocate. Supposing there is a dispute which is clearly not arbitrable. Let's take a very extreme case, a divorce petition goes to arbitration. In our Indian law, and Vidya Drolia says that first the arbitrators will decide. Okay, fine, no problem. Under section 16, which is the equivalent of article 16 of the model law, which is the same that you have all over the world, competence. But then you have a situation that you wait till the end of the arbitration to challenge. So you have to suffer an entire 1.5 to 2 years of an arbitration which is non-arbitrable. Is that fair, or should you have some sort of recourse at the section 16 stage?
Gaurav, if I may, with the permission of, finish your.
So that's the question. I mean, I just wonder whether if we are being too pro-arbitrator and too pro-arbitral, which is our default thought.
Yes. In fact,
or say it's an insolvency dispute and you're having an arbitration. And let me give you a better example. Forget the divorce one. Supposing there's an insolvency dispute, there's a resolution plan. The resolution plan is passed. Everything is fine. Despite this, the arbitrators say nothing doing. Win the resolution plan. This is arbitrable. Forget the insolvency. Let's decide this issue in a year on the merits. What's the remedy? Or should we just wait?
Yeah. In Singapore, actually, Gaurav, there's a clear answer to this in the International Arbitration Act. Because unlike in India, where if a tribunal decides that it has jurisdiction, right, you'll have to just wait till the end of the matter. But in Singapore, if the tribunal decides that it has jurisdiction or it decides otherwise, both a positive ruling and a negative ruling. The negative ruling was recently amended. In both situations, you can go to appeal to the High Court in Singapore under the International Arbitration Act. So we don't have an equivalent provision in India. Of course, this depends on the legislative, kind of provisions in each different country. But unlike Singapore, I don't know how many jurisdictions has this express provision. And so it begs the point that you kind of made, that why if there is no express provision, then you'll have to just wait till the award is made, go through the entire thing, and then challenge the award if a tribunal find that it indeed has jurisdiction to deal with such a case. So I'm sure, I think I jumped the gun. Probably Francis wanted to say something on this.
You're the chair, Ganesh. You jump in anytime you want. But Gaurav, you raised a very important question. And I don't think even in Singapore, it's been completely resolved. And while, as Ganesh says, once the issue of arbitrability at first instance is decided by, say, a Singapore tribunal, either negative or positive ruling, you can appeal that to a court and take it all the way to the Court of Appeal. But I think your question is a bit more nuanced, which is, what if the person who loses the question doesn't take on that appeal, but sits back and says, you know what, I'm going to challenge it either at the setting aside stage or at the enforcement stage, right? And I think that issue is a live issue, because I think there is a strong argument. And, I know in one case, Justice Quentin Lowe came close to saying you really can't do it, because effectively you are sort of blowing hot and cold, right?
Yeah.
Right. And you are giving the impression that you've given it up. It's like a procedural waiver.
Right.
But I think this issue, unfortunately, there is a lot of fertile ground for advocacy in future. It's not an open and shut debate. If a party doesn't exhaust or pursue its rights that Ganesh has said, and then reserves its powder
for enforcement,
right, at the setting aside or enforcement stage, by which time it says, even though I fight the merits, if I lose, I will resurrect this point, so but that's a very good point, Gaurav.
Any thoughts, Jan? Jurisdiction, and then you have to wait till the end.
Yeah, and no, we have a similar mechanism like in Singapore, but so if the arbitrators determine their competence, then and they say we are competent, then you can challenge that with the German courts. And if you don't challenge it, I think you should be treated as if you've waived that right. You can't reserve it and bring it up back again, because that would be just a kind of a contradictory behavior. But at the same time, in Germany, if the tribunal says we are not competent, there's no remedy against that. So you're definitely stuck with the courts in that scenario. But in terms of German efficiency, the German legislature even brought in something else. That means before the arbitral tribunal is constituted, a party can go to a German court and ask for a declaratory relief, whether the arbitration agreement is valid, whether the arbitration can go ahead. Of course, that poses their own problems, because you can bring the arbitration in parallel while this is ongoing. It's different judges. The judge in the for the question of whether you are competent, it's the Court of Appeal. It's a second level judge. But the question where you can table the question before whether there's a valid arbitration clause or an operable arbitration clause, or this kind of terminology used, that would be the kind of district court judge. So that would be a different level of judge. So this is a whole way. It's thought to be to serve efficiency, so that nobody is dragged into an arbitration, and you have to continue for 2 years spending all the time and the money just to sort it out. In the end, the whole thing goes away and you are back to square one. But of course, it's a complicated mechanism.
Interesting. Thank you very much. I think we have kind of, unless there are any other thoughts, anything, Gaurav, you wish to add to what Francis or Jan said?
No, I think I've tossed the ball into the court once too often, so I will hold my peace.
Sure.
Ganesh, if I could just add this for the
Yes.
benefit of those listening.
Yes.
The CIR recognizes that there are and a number of the issues were raised by Gaurav and Jan and yourself. Cross-border insolvency and restructuring efforts across the world create a conundrum of issues, not least because different jurisdictions approach it very, very differently. And so the CIR, earlier this year, I constituted in consultation with Sundaresh, Chief Justice Menon. We are working with the Judicial Insolvency Network. We formed a high-level steering committee to look into the question of harmonizing the global rules for cross-border insolvency and restructuring, and in particular to make recommendations on the use of arbitration to resolve a lot of these disparate approaches and solutions. But that's something that's the CIF is working on. Thank you. Back to you, Ganesh.
Oh, great to hear that. Good to hear that Chartered Institute is working on this. Before I hand over to the president of Madhyam, it was an enlightening session for me, Gaurav, Francis, and Jan. On a lighter vein, on a Saturday afternoon, we have spoken about booze, Alan, and also in rum. So just to end on a lighter note, we are not just boring lawyers, we also like fun. Yeah. Back to our President Ji, Mr. Amarjit Singh Chandiok.
Thank you, all of you, Ganesh, Gaurav Banerjee, Mr. Francis and Jan. Thank you for that enlightening debate on arbitrability. I think it has reminded me of, to tell Gaurav this, that I was campaigning for my presidency in the Delhi High Court Bar when I went to a district court, and I was told that unless I have a cup of tea with them, they're not going to come to support me. So I sat down and I find a lawyer had two, a male and a female, both husband and wife, it looked to me. I mean, later on I came to know about it. And this man just told his clerk, go and get it notarized. So he comes back with a notarized 2 documents and he says, you are divorced now. So that gave me a shocking situation, that how do they get divorced by 2 affidavits? So I asked this lawyer, what are you doing? He says, the other side of the table in this district court where marriage is recorded, and this side we divorce the possession. So that's the position in divorce in some cases, but that's on a lighter vein. But I was only wondering to request all of you to consider if today's situation is that we can both agree as spouses to jointly move the court for a divorce on mutual consent. Now, mutual consent is an essential part of a contract, really speaking, though in Indian law, we don't consider marriage as a contract, but we now have recognized divorce as a contract in that sense that we both agree. Then if that can be settled, if that's a part of it, then why it is not possible to settle that dispute? Yes, maybe the final part will have to go to court, I understand. And I also want to flag it one more situation, as I think what one of us gave is, I think Gaurav gave, and I think Jan gave, that if you can settle a dispute by money, then you have pecuniary interest in it, and therefore it should be arbitrable. So I find almost everywhere, whether I go to insolvency also, a financial creditor is only looking at a pecuniary interest. He's only wanting his money back. Maybe he gets 50% or he gets 40% in insolvency resolution. So in that sense of the matter, arbitrability may have a wider range to look at today, though I understand today there's a code is now looking at. In fact, so far my experience of insolvency tells me that there's so many disputes that are coming today inter se, which can be resolved. And I think this pandemic gave us an opportunity, and we found that many financial creditors were ready to settle down in a mediation settlement, though not strictly mediation referred by court, but mediation was sent to us and we mediated and probably resolved the dispute. And I'm so happy to see amongst our participants and audience today, eminent judge of the Supreme Court, Justice Sikri himself is attending and looking at it to see how these eminent people have come forward and looked at it. And I think we have now expanded the scope of it. I think you're right, absolutely. Justice Khanna has now given us a throwaway sentence on copyright. But if I look at the situation today, and I don't think it's really a block saying dockets are increasing in Indian court, and I still always maintain that we should be proud of this fact that still people in India feel rule of law is important, and therefore they knock the doors of the court. But from alternative dispute resolution, it has actually become appropriate dispute resolution situation. We have reached that stage. Then with the help of people like from the charter, from Mrs. Xavier, Zan and everybody, Ganesh, you at the top, and Gaurav in any case in our field to lead us, I'm sure we'll be able to take this forward and bring more things. The only thing probably out of what I think Gaurav, the issue has raised, and he put that question, I think probably the legislature must look at it, that if there is actually a dispute at 16 of the arbitral tribunal, some window must be opened for parties to, because if there is no statutory remedy available to me, I can't file an appeal. So how do I say I waive it? What then raised that issue that you deemed to have waived it. But those are jurisdictions where appeal, it is maintained. You can file an appeal. You can go to the court. But in Indian law, if I don't have that right, then the waiver will not come in so far as the Indian law is concerned. But looking at the situation today, I think we have moved forward after 2015 amendment, in particular in the Arbitration Act. We have moved our chapters much faster than we thought. The arbitral tribunals are looking forward to resolve the matters. And I find a dispute now between financial creditors who will get priority. That itself is a matter which has come for a settlement, and we have resolved that so far. Now, if that is dispute which can be resolved, I'm sure we can do it. And I also want to look at one thing else, Section 12A, which is now added in the insolvency code, where if 90% of the creditors agree, so it's a settlement. I think that's, if my section is not wrong, now if 90% of the creditors agree to I can withdraw the insolvency. So that REM situation would take a turn now, if that's the situation today coming into position. So all this is now changing. I think the whole atmosphere of arbitrability is changing with this judgment of clarity by the 3 judges bench. We'll go forward, and I think the next part would be probably what Ganesh told us today, pecuniary interest, and see if we can resolve that into it. I have no words to thank each one of you from the core of my heart, from each member of Madhyam. We look forward, because that the exchange of this clarity by you, international people, national people, the leaders in arbitration, to tell us what we should be way forward. We will again bother you time and again. We are sure you will move to our request and would probably be with us to have more clarity on more issues that are arising. Conflict of interest is one more issue that I think is ranging up and down with many of us. And I can see the smile on the face of Gaurav in this respect of that. But yes, we'll sure like to have those clarities. And I think the more clarity that you people give to the participants, the assistance to the court becomes essential. They learn from it, and ultimately it's the assistance to the honorable courts that gets the well thing to do that. As Gaurav has pointed out, when I read that judgment, which he was referring to, that after the award, still the Supreme Court said you can't, this Nariman said you can't invoke the arbitration because 34 is pending. Now, on one hand, we have come to say if 36(2) is, no order is passed, award is enforceable. Now, if it is enforceable, then why can't I make a claim? That question is still left to be debated. And I think I, in fact, had the occasion to say that yesterday, therefore, on the last day, in fact, of the Supreme Court functioning, to the bench of Justice Rao, to say, thank you, my Lord, for giving us judgments time and again from the Supreme Court and all high courts. But I think all of you are lawyers by and large still, notwithstanding that you are judges. So you leave some window open for us to debate again before your lordships. And I think that's the way we are looking at things. I, on behalf of Madhyam, also thank my participants for a Sunday afternoon to spend with us. But this exchange of knowledge, the clarity that we get from all these experts, I thank you from the core of my heart once again. Wish you a Merry Christmas. Wish you a very happy New Year. And also a prayer for all of you, your families, that let 2021 be free from COVID, free from all this that humanity is suffering, and we may have a better time to spend. Maybe we have from virtual, we go back to hybrid, if not totally physical situations, and we look forward to have your more participations with Madhyam. Thank you very much, all of you. Thanks once again, and thank you for spending your Saturday afternoon with us. Thanks a lot.
Thank you, Mr. Chandyok. Thank you, Ganesh.
Thank you. Thank you.